Welcome. It is January 31st, and we are in the Judiciary Committee continuing testimony on H89. On the agenda, it does say that Michelle Childs would be testifying, but actually she is not going to be. There's no need for her at this point. So we're going to move right to Dr. McAfee. So if you could unmute yourself and identify yourself for the record and proceed.
Sure thing. Good afternoon, everybody. My name is Dr. Lauren McAfee. Thank you for the invitation to testify today. I'm an obstetrician gynecologist and complex family planning specialist in Burlington. I'm here today as a member of the Vermont Medical Society, as well as the Vermont section of the American College of Obstetricians and Gynecologists, to voice my support for H89. As an OBGYN that provides comprehensive reproductive health services, including abortion care, I recognize all too well the potential risks, both personally and professionally, with providing services that are politically charged. Across the country, we've seen a dramatic rise in the threats and violent acts against healthcare providers and clinics, particularly those that provide reproductive health care, including abortion and gender-affirming care. In a time where we are seeing healthcare providers facing tremendous levels of burnout, fatigue, and leaving medicine for other professions, it's critical that we do everything we can to protect and support our healthcare workforce. With rising financial challenges, political interference in medicine, and increasing patient demand in supportive states for reproductive health services, health providers are burdened with the additional concerns of their safety and ability to provide care for the increasing number of patients traveling from out of state for safe, legal health care. When I made the decision to include abortion care in my practice, I knew I would need to be particularly careful around my and my family's safety, more so than most health providers. I thought hard about which states would best allow me to provide compassionate, evidence-based healthcare with as little political interference as possible. Since returning to Vermont in 2016, I've been grateful that Vermont continues to lead the way in affirming a patient's access to reproductive health services. Shield laws are an important piece of reaffirming our state's commitment to making reproductive health services accessible to our patients. Protection for our healthcare providers helps reduce risks and provide support as they strive to provide comprehensive care for patients. I applaud our legislators for bringing this legislation to the table and voice my full support and appreciation for H89. Thanks so much for your time and support.
Thank you. And are you available to take any questions if we have questions?
Of course.
Appreciate it. Any questions? Sometimes it takes a moment for us to warm up our questioning. So
no problem. I'm a fast speaker too, so.
I guess I'll just start as well. So have you seen an increase in out-of-state individuals coming to Vermont to receive reproductive health care services?
We historically have always seen patients who've traveled across state lines to seek a variety of different care, partly because of our geographical location, but also partly because of some of the increasing restrictions in other states. I don't know that I have specific data to say that, yes, our volumes are higher. I believe Lucy is speaking later from a Planned Parenthood perspective. She may have that data available, but we have certainly seen more patients coming and expressing concerns as they've had to cross state lines about potential ramifications for the care that they're seeking.
Right, thank you. Other questions? I think we're fine, and I really appreciate your testimony. I thank you very much for taking some time out of your day.
Yeah, my pleasure. Thank you all so much for all the work you do.
Yep. All right, and we will move on to Lucy. And you're already close to the chair, so this is good.
Yeah. Close to the door and close to the chair. Good strategic locations. For the record, Lucy LaRiche, Vice President of Public Affairs for Planned Parenthood Northern New England and Planned Parenthood Vermont Action Fund. I'm here just to, once again, thank you all for taking up this bill and doing the hard work of trying to untangle this big ball of threads. It is complex. At the highest level, I just want to add that I have shared the draft with our national policy experts, our litigation, lit and law team at the National Planned Parenthood Federation of America. And they had offered some edits, which I sent to to you, Mr. Chair, and I'm just here to go over those edits. From a high level, I would say that they are all friendly and mostly technical in nature. The first has to do with the definition of legally protected healthcare. And it's legally protected healthcare activity.
You hold on for just 1 second. I'm trying to find that. I'm going to have Nina post that, but I'm having trouble finding.
Sure, I sent just an email to you, was to you and to Representative Donnelly, I think on Representative Donnelly's last day,
Yeah.
which was what, last Thursday or Friday? Sad.
It's texted.
I can resend it. I don't think I did include Panina in that email, but let me see if I can surface that quickly.
Okay, you said it on Friday?
Yep. And I found it and I'm forwarding it to you now.
Okay, yeah. Panina, if you could post that so folks can bring it up and take a look.
And
You know, sometimes they just disappear. I don't.
I know, literally, like off your when it's off my screen, it's like it never existed, right? It's so hard to keep up.
Lucy just said it.
Yeah, I just barely sent it to the two of you. And so at a high level, as while we are waiting to get your eyes on that document, at the highest level, I will just say that we have just some tweaks around the definition of legally protected healthcare activity, and also around this wrap of who exactly is included in that. And we are aware that you wanted to include health insurance carriers in that. And so these suggestions are really in the spirit of trying to make that clear, make the definitions clearer, that insurance companies are included, and to also include them in places where it makes sense to include them and take them out where it doesn't make sense to include them. So I know that Sarah is going to be testifying at some point on this as well, and she also has some definition suggestions. So of course, understanding that there are probably lots of ways to draft this, and these are just suggestions, but that is the intent of the change, that we are hoping to clarify where it's appropriate for healthcare providers to be included in the definition or in any particular section, and to make sure it's clear that they're included. So however you want to use that language.
And I did email it to everybody as well. You will also be on the committee page.
So the first suggestion is on page 5 of the bill, or at least the last draft of the bill that I had. I understand that there was another bill, another draft.
We're still working on it.
Okay, great. So these page numbers will still make sense. And on line 3 and 4 on page 5, striking "or the provision of insurance coverage for such services." And that is for clarity there. And then on line 8, this is the first example of where we recommend removing this from the definition of legally protected healthcare activity. And so this is an example of that. And then on line 13, now the new 911, I guess, regardless of the patient's location, I know I already testified to this point, but we just want to be clear that this bill really can only go so far as to protect what happens within the borders of Vermont, like a firewall around the state. And we want to just be clear that it is not our understanding that this would protect a patient who was receiving care via telemedicine in a state where abortion or gender-affirming care was banned. The next change is on page 7 and on line 15, and this is an attempt to include insurance coverage in the definition of legally protected healthcare activity. Again, this could be done different ways. And then on page 9, the words, having the language aids in, access to, aids or abets.
So can you, 1 second, I want to make sure that we're all following where you are. So the previous was under section 4, under 1A, is that correct?
Yes, section 4, 1A.
And that would be adding the language, abuse of litigation means litigation or other legal action to deter, prevent, sanction, or punish any person engaging in legally protected healthcare activity. And here's the additional language, or any person who provides insurance coverage for legally protected healthcare activity. Okay.
Okay. And then on page 9, the folks that I spoke to, the legal experts I spoke to, believe that having the words aids in, access to, aids or abets, the way that this is drafted, they believe that it already covers insurance providers or the insurance providers. But again, I would leave it to Blue Cross or others to confirm that they feel comfortable with that, or if they have other revisions or a different way of doing it that they think would be more protective for them, or that they would feel more comfortable with, it would be clearer.
Okay.
And Lucy, sorry, that's.
Go ahead.
I'm sorry, line 4, right, on that page?
Yes.
Okay.
Yeah, the understanding is that our legal folks just thought that by using the words aids and abets, that they're already included in this section. And the next proposed change is on page 11. There was just a feeling that issued without jurisdiction was redundant because in order for a judgment to be issued, there has to be jurisdiction. Again, this is technical and outside of my particular area of expertise, but do with that what you will. That was the suggestion from our legal folks at the national office. And there was also the suggestion to add the words penal in nature to because they felt it was additionally protective for the full faith and credit clause of the U.S. Constitution, to further protection for the U.S. constitutional challenges.
So that would be leaving one of the requirements for domesticating a foreign judgment. One of the requirements is jurisdiction. Another requirement is that it's not penal in nature. Actually, I'm going to be suggesting actually adding something rather than taking something away, that it's issued without jurisdiction and the individual did not have notice and opportunity to be heard or something to that effect. So wanting to lay out all the factors that have to be shown for a foreign judgment to be domesticated. And the purpose is, we probably don't have to have this in here at all because the court's going to do that. But I think.
But if there's no harm from
spelling it out just makes a lot of sense.
yeah, there's no harm in having it.
And adding the notice and opportunity to be heard in there as well. So.
Yep. And then a few lines down under 7304 testimony and documents in the last line, there is that same language again to capture insurance carriers. Yeah, okay. And then on page 12, let's see, on line 5, on subsection 2, the word assisting. It's, again, a technical thing around whether insurance is captured in that. And then you can add additional language to make it clear that you're talking about insurance or not. But the feeling is that that word does cover insurance.
Okay.
Okay, and then in section 5, interference with access to healthcare facility. These edits really are to try to make it clear that it's about entering and exiting healthcare, exiting for healthcare services. The way it's written, there was a feeling that maybe it could be interpreted as being a little broader than that.
So you want it broader than what we had. Is that correct?
Healthcare, it's actually a little more narrow, a little more specific to add healthcare services.
But I thought that if you have legally protected healthcare activity, that's narrower if you're expanding it just to all healthcare services.
Oh, that's true. That's true. That's true. You're right. So, so the federal FACE, I'm trying to remember how this intersects with the Federal FACE Act. Part of the problem is my memory is not so good. I may have to get back to you with more specificity about the thinking behind these suggested changes in this section.
That's fine. Yeah, that's fine. To do that. It seemed straightforward to me that it seems to be expanding the protections. And I'm not opposed to that. I think it probably makes sense. It shouldn't be blocking people from whatever their healthcare services that they're receiving. Providing.
And then the other thing I'll mention is under section 9402, again, it's once again legally protected healthcare activity. These are really technical changes. They really are not substantive. These really are. It's really a drafting problem, and it needs to be. Our folks our legal folks believe that this needs to be narrowed down to service.
So can you tell me where you're looking at again?
I'm looking on page 13 under section 9402. Line 14, the suggestion is to strike legally protected healthcare activity. And it's technically how it interfaces with healthcare services. It's like, it's not, her comment is it's not appropriate to reference this definition, given the definition goes well beyond the provision of healthcare and instead reaches the rights to reproductive healthcare services.
Okay. That's a question.
Yeah, please.
I'm just trying to also see, so at the beginning of this bill, we create the definition of legally protected healthcare activities. And so I feel like it's important to be using the same one throughout, but it sounds like you're saying this is dealing with something different than what we defined at the beginning.
Because what you defined at the beginning refers to services, and this section defines is referring to a facility.
Okay.
It's technical in nature. It's,
Well,
and I'm happy to have a conversation with Michelle too, this on the side to kind of talk this through and maybe get our legal folks on the phone with Michelle to talk it through with her. And they can maybe interpret it for you.
yeah, I guess I'm just trying to understand what the comments as well. That I would assume the question is whether, and we can work the language out with Michelle. The question seems to be whether we're narrowing it to just be facilities offering reproductive health care and gender affirming care, or if we want it broader.
If you want it broader.
I think that's as I'm seeing this, and we can have a discussion on that. We can.
And there's a federal law that does protect access to healthcare facilities.
Right.
But this is all going,
Oh, I'm sorry.
the change on this or the confusion or whatever you want to say on this is all because of the BSA 9402? Is that what this is, where the change is about?
I'm sorry, would you mind repeating that question?
So where the healthcare provider or the protected healthcare activity, you're saying that should be changed because we've gone under BSA 9402?
Because they're referring to different things. One is about the provision of healthcare and protecting human beings who are either accessing healthcare or providing healthcare. And another is about accessing a facility, providing healthcare, as opposed to a service. It is protecting the people who are accessing healthcare, yes, but it's also about accessing a facility and a physical protection in order to access that facility. Like it's not a buffer zone, but access, so that you can't block access to a healthcare facility.
So as I read this, Ken, the main issue is whether we're just talking about healthcare services or legally protected healthcare activity, which is narrower. So presumably, with these changes, as I understand them, any kind of physical blocking or interference with access to a facility, whatever the reason the person is going to the facility, would be barred under this.
So I guess my thing with that would be is I just have to see what 9402 is so I understand where we're going.
So 9402 means
I knew you'd have it.
Healthcare provider means a person, partnership, or corporation other than a facility or institution licensed or certified or authorized by law to provide professional healthcare service in the state to an individual during that individual's medical care, treatment, or confinement.
Thank you.
I think the rest of those changes there were with respect to.
Yes, same issue.
So I want to understand a little more why the change with respect to insurers. If you could.
It's really for clarity to make sure, because the way it's written, it's not entirely clear that healthcare carriers or insurance carriers rather are captured in that. And so these suggestions are really about creating a little more clarity to make sure that it's understood that insurance carriers are also captured in these protections where it's appropriate.
All right, and did you say this has been shared with Sarah Teachout, who's going to be?
I haven't shared this We just had a quick little sidebar, and Sarah can testify, but she said that she does not believe insurance companies are adequately are clearly enough defined or included in this. I'm sure she will say more about that when she sits in the chair.
No, that makes sense. Okay, because I guess I wasn't sure how this changes accomplish that one way or another. It just seemed to be moving some things around, and I kind of actually haven't been buying the reason for taking it out of the definition yet, but certainly can be
Okay.
persuaded.
That's cool.
The thing is, I will say that we definitely intend this to be protecting the insurers. Yeah, so.
Yeah, so if that's the intention, I feel like they're between, maybe some folks can get together and just make sure that everyone is comfortable that's there. Again, it doesn't have to be with this language or in this way, but that's the high level feedback, is that could be clearer, that insurance companies are included, protections for insurance companies and carriers are included in these provisions where appropriate.
Karen?
Yes, so looking at, it's on page 14, I guess it's line 3, so it's switching gears to a different topic, where the edit is suggesting adding entering or exiting the healthcare facility. And I think you shared at the beginning that is specifically clarified because it's related to a facility. I'm just curious if that actually limits protection at all, because I feel like it would need to be defined that somebody is entering or exiting, that just they could be standing there. What does it mean to be entering and exit? Wouldn't we want to protect anybody that's near there trying to access care? I just worry, so I'm just asking that question.
Yeah, I think clearly the intent here is to provide protection for people and rights for people to access healthcare and for people to provide healthcare. And part of that access means that they have to enter and exit a healthcare facility. Clearly, that's what you intended with this section. And so you're saying that by including the words entering and exiting a healthcare facility, your concern is that it narrows it?
Yeah.
The feedback that I got from our legal person, I wish she were sitting in this chair, frankly, was that it provides more clarity in her mind. It provides more clarity.
I feel like it might be something just to consider. I'd just be curious, because to me, it feels like it's narrowing and that it probably was included in how it was before. But if it's really important that that's there for some reason,
Well, it makes it clear that it doesn't apply to a healthcare provider, for example, exiting or entering their own home. If you wanted to add that, then that's different. But given what we understood to be the intent of this section, she thought that making it clear that it was for a healthcare facility would mean that it wouldn't apply in other circumstances if she's going to a healthcare provider is going to a supermarket or going in and out of her home or some other place.
Okay. We need to look at that a little more closely, and we don't want to narrow it, and we'll just have to look at that and think about it a little bit more. Other questions right now for Lucy?
And the other change on this page in subsection 2, same issue. There.
Okay, I think there aren't any other questions at the moment. Oh, I'm sorry, did I miss, are there some more?
No, I was just going to say the other one on this page, on page 14, on line 17, is again the same definition issue. And then the last change, again on 17, a definition as well on and a technical issue on whether or not you want to include insurance companies in the case of extradition, I believe. Is this extradition?
Line 17, right?
Yes. Oh, I'm sorry. Page 17, line 10 is one change, and page 14, line 17. under legally protected healthcare activity, line 17. So section 6.
So this is line 17, but it's on where you have some changes, so it's probably a little bit different place than what we're looking at. So it's, I'll orient people. I think it's section 4970,
Yeah,
which is on page 14, and it's
line 17.
line 17 there. Okay, so this is a place that possibly,
The question here is whether or not someone who's providing insurance would be subject to extradition. Our legal folks didn't think that seemed likely.
the insurer would have to be in the state where seeking extradition, would have to be physically located there, presumably, when the actions occur.
When the actions occurred. And nonetheless, it's like, can you extradite an insurance company? Like you would be extraditing an individual, and individuals are covered in other portions of the bill. That was the thinking about that.
I'm sure we'll hear more from
Yeah.
how she thinks we should best protect folks who are providing insurance for these procedures, yeah.
And again, the last change, or the last comment rather, not change, it's on page 17, line 10. Just wondering if it makes sense to include insurance companies in a definition, insurance companies in the definition in this provision.
Right, for the address protection.
Yeah. Yeah, that didn't really make sense for an insurance company to, Blue Cross is not going to have their mail forwarded to wherever.
Thank you for that.
And those are all of the suggested changes from our national legal shop. And again, sorry, I wasn't totally clear on a couple of them, but happy to work to provide whatever clarity is necessary. And again, Blue Cross may have some better suggestions anyhow, but that was the high level feedback. And to your question about an increase, Dr. McAfee, someone asked Dr. McAfee about an increase from out-of-state patients seeking care in Vermont. And for Planned Parenthood, we started tracking that in the fall. And I haven't looked at the data since, but in the early fall, we were looking at about a 10% increase in patients who were seeking abortion care from other states.
Appreciate that.
Sure.
Right, so I think we're going to go directly, sorry, Judge, we're going to skip Sarah Teach out as our next witness to follow up on what we've been talking about. You can identify yourself for the record and proceed.
Yes, good afternoon. I'm Sarah Teachout. I'm the Director of Government Relations for Blue Cross and Blue Shield of Vermont. I'm not typically in this committee, so I'll just give a 2-second introduction. I have been there for 5 years, and for 16 years before that, I worked in the Joint Fiscal Office as a tax analyst. So I know some people in the building, but fewer and fewer every year. Blue Cross and Blue Shield of Vermont is locally located. We're up in Berlin. Independent Blue plan. So if you're not familiar with the Blue system, it's 34 companies that operate a little bit like franchises. So we have the state of Vermont, and that's the only place we sell insurance and the only people we provide insurance to. We are sort of, they say, knit together with the rest of the Blue system because we share a network so that our members can travel anywhere in the United States or internationally and seek care, and the services are paid for through the network of all 34 Blues plans. So that's just the quick overview. We're also a not-for-profit. Every Blue plan except for one, which is Anthem Elevance, they are a for-profit Blue plan. So just to give you a little background. So we, to start very high level, we're very much in support of this legislation and we appreciate you taking it up. And to give you a little background, Blue Cross and Blue Shield of Vermont tries to offer services that our members and the employers in our state want. And they do want access to abortion and reproductive care services as well as gender affirming care. So we offer these, coverage in all of our healthcare plans. The other thing is when the Dobbs decision came down, we created a travel rider as an optional additional benefit for self-funded employers to offer for their members. So when we were thinking about some of the issues created by that, what we were thinking about is a family here in Vermont who has Blue Cross and Blue Shield of Vermont coverage, and most of the family lives here and receives services here, but they may have a college student who's away in another state, and that person may want these services and need to travel. So that allows them to travel anywhere that it's legal to obtain those services. So once we did that, then we got into some of these legal issues with what other states are trying to do with the aiding and abetting laws that are criminal. So just to give you the background about why I'm here and what we care about in this bill. Our legal counsel was also looking at the definitions section, had a different approach than what you just heard from Lucy, but was concerned that it didn't adequately include health insurers. I would say that we actually want the definition to be broader. We think about it as a payer because it's not just the health insurer. We're providing health care coverage for self-funded employers. So they're actually the payer and they're legally liable, we believe. And it could be also someone else paying for the care that's not related to the health insurance company or the employer. So we really think that you should broaden that beyond carrier. We use the term payer. There could be a better term, but I just wanted to start with that.
Is that the language you would suggest? And do you have the draft in front of you?
I do have the draft.
Language suggestion.
So I'll tell you where in definitions, we started with both the definition of reproductive healthcare services and gender affirming healthcare services. These are on page 4 and 5. And we would have added, including providing insurance coverage for any of the foregoing. So you have the whole list of things that in that definition. And then that's where we chose to add health insurance.
So you're fine with it in subsection B?
Yes.
Right there, and the provision of insurance coverage for such services, but want to add including, could you say that language again?
So, and I can email it to you, including providing insurance coverage for any of the foregoing. And we would add that both to gender affirming healthcare services on page 4 and then reproductive healthcare services on page 5.
Okay.
So then to jump down, section 3 in the privilege from arrest, which is on pages 6 and 7. I think we would have preferred a more straightforward prohibition. Something that said along these lines, law enforcement should not cooperate with or provide information to any individual or out-of-state agency or department regarding any case involving abusive litigation. So we're just looking for something more direct than the prohibition, which starts at the bottom of page 6. The person should not be subject to civil arrest.
Right, so slightly different animal, I think.
Okay.
As far as what civil arrest is, and hopefully we'll get some more testimony of precisely what that means and whether that's a necessary change there. I don't know how often law enforcement is involved in civil arrest.
Oh, right. Okay.
And I'll flag this for our next witness, Judge Zone, if he can give us a little insight on how that provision.
Okay.
What that provision applies.
We're totally flexible as long as you achieve the purpose. So the next place that our legal counsel had some concerns were in the section 4. I'm probably not saying it right, but the tortious interference. Tortious. Yes, sorry.
For defendant, it may be torturous.
Right. So the concern here is that if Blue Cross was served a subpoena to provide some, we're thinking probably healthcare records or other information, we would, I think what we see here is we wanted to reverse the burden of production proof to the entity seeking the subpoena, rather than having us prove that it's what are you using the word here? Sorry. Rather than having us prove that it's I'm forgetting the term. Anyway, reverse the burden of proof is what we're thinking. And I think the other thing that our legal counsel suggested is changing the standard of review to be clear and convincing evidence rather than the default standard of the preponderance of the evidence, which this is, I think, implied, but let's see. I'm just looking for it. Bottom of page 8, beginning on page 8. And I can send it to you in writing as well.
Is that changing the burden of proof for getting a subpoena honored? Is that the idea?
Yes, to make it more difficult. So we'd like to have it be on the entity seeking the subpoena to do the burden of proof, and then have it be a higher bar, I think would be the quick summary. And then on page 9, I think our other thought was if you didn't want to reverse the burden of proof, then be able to recover costs for defending against these cases. Only in the instance that we prevail.
Right.
And then the last area that we had a recommended change was on page 11, the testimony and documents. Our legal counsel was concerned that the term person in line 8, so page 11, line 8, didn't include the insurer because it's the word person. And, I don't know how you're using it there, but that it should be provider, carrier, or other entity or payer.
I thought person included companies and organizations and insurers and like.
In this section, I just don't know. So we just wanted to be clear.
Yep, gotcha.
So that's the big picture. I'm happy to send you the specific language that we recommended. Obviously, you're going to get a lot of recommendations, it sounds like, so
No, I appreciate that.
look at which ones are the best.
And I assume that the insurers don't want the protection of the confidentiality of their addresses. We want to make sure it's right. So, all right, I really appreciate that.
So, that's great that you're thinking about the people that are employee or self-insured through Blue Cross as well. Will that cover HRSA, people that have those kind of accounts? I don't know if Blue Cross does that, or if we need to be talking to other. And again, I don't even know if that's our committee that does that, but that started me thinking about that.
Right. I think, again, we use the term payer, and I don't know if you would need to define it here, but we use the term payer to include everyone paying for the services. So it could, that's a much broader way to approach it, I think.
So my other question is this. When people are seeking care from somebody in the Blue Cross network, does it specify, I can't remember if this was end of life legislation that we did, but there was some legislation that we did that discussed people being doctors or providers getting to choose if they were going to provide a certain type of service. So I'm wondering if, and this sort of cuts in both ways in terms of protections, but also expediency, if there are providers that do not offer some of these treatments that we're talking about, either an abortion or gender affirming care. And I'm thinking of an abortion more because obviously the other is more specialized. Is that is there like a little asterisk? So 'cause I'm aware of situations where people have had a fetal demise in their pregnancy and their physician doesn't perform abortions. And even though there was a fetal demise, care was not available. And so I'm just wondering, both from protecting people, because obviously if there's a little star next to their name that they would help someone terminate a pregnancy that was not going to be successful in a live birth. So I'm trying, again, like it would be great for patients to know that, but I'm thinking just in terms of neon lights for people feeling vulnerable from being sued from other states, having that little asterisk saying, yes, we provide that kind of care is an issue. And I don't know if those discussions have.
Yeah, I'm not sure if that's something that we have discussed or that we provide the information for, because generally, we deal with providers who are practicing within the scope of their license, and we don't
get into that
much further.
Again, maybe it was the end of life. Like there was something where it was like, can we put up that we do not do that?
Interesting.
And so I can't remember which panel it was, but.
Okay.
And again, it's not like extra protection for people that have the asterisk, but again, I would hate for somebody to have to spend time and medical resources and their own resources going to a physician that wasn't able to help them.
Right, I understand. And you know what, I'll look up the other piece because I can't remember, to be honest. But.
Any other questions? I appreciate the input. Thank you.
Thank you for. Yep.
Check zoning.
It's like musical chairs over in this corner.
Nice to see you again.
Good to see you. Good afternoon. So my name is Tom Zone, and I'm the Chief Superior Judge. As I have said a number of times before the committee, I think just last week, in response to a question that I received, it is not my intention to weigh in on policy, and it's not my intention to weigh in on the constitutionality of provisions. I'm aware that this committee has heard on policy matters and constitutionality issues from a number of witnesses. So my intention when I was looking at this bill was to see if you look at what the legislature is trying to accomplish through a statutory framework, what are areas that there might be inconsistencies, procedural gaps, or conflicts such that might make it more difficult for the transparency and predictability that is fair to everyone in the legislative and judicial process. And so with that, I have several points that I thought I would raise and just point out to the group. And on page 9 of page 89, on line 15, the section talks about the ability of someone to file for a civil action in response. And the draft of the bill sets forth a 3-year period in which to do that. Under Vermont law, Title 12, Section 511, our general civil statute of limitations is 6 years. So you may wish to consider bringing that in line with what would otherwise be the statute of limitations for a civil action. Personal injury would be a 3-year limitations period. Below that, in subsection D on line 19, this provision seeks to allow a defendant the opportunity to file to modify, quash, or take other action if they're served with a subpoena. The language that's currently in this proposal says unreasonable or oppressive or inconsistent with the public policy of this state. The Vermont Rules of Civil Procedure currently have Rule 26. Rule 26 is a rule which actually provides protections in the discovery process, which is where this would fall. And so I would suggest that in line 18, where it says subpoena issued in conjunction with such abusive litigation as provided for under the applicable rules of civil procedure and on the grounds that it is inconsistent with the public policy of this state. That way, you are making it clear that you're not trying to supersede Rules 26 and its established precedent in this section, but rather building upon that because it appears clear that what the legislature wants to do is add the inconsistent with public policy of that section.
So could you say that again, or would you email that language twice?
I can send it. I can email if that's easier.
May I ask a question?
Karen.
Just because you mentioned the line 15?
Yes.
3 years, and I feel like that was one that we had a question of how would that be interpreted of when that clock starts for that?
That would be a determination based upon a number of factors at the time of the suit being brought. We have a well-established body of case law as to determining statutes. It would be difficult to say exactly how it would be determined. That would require me, in essence, to tell you, here's a legal decision on something. I would note that if you chose the 6-year period, it provides a broader period of time for individuals to seek their remedies and less of an opportunity for them to feel as though they haven't had an adequate opportunity to do it and may have been shut out from pursuing them.
And the 6 is in line with what you said for other civil
Yes.
actions and stuff?
Yes.
Okay, that's helpful.
On page 11, I would note that in section, the first section, 7303, I would just follow up on something Representative Lalonde mentioned earlier during one of the witnesses, and that was where he commented about without jurisdiction and without notice and opportunity to be heard. That would bring that section in line with the case called H&E Equipment versus Cassani, I believe, which is what that would be doing is actually having it mimic what is already existing law in Vermont. As determined by the Supreme Court when looking at enforcement of foreign judgments. The next section, 7304, in line 7, it says, notwithstanding any other provision of this title to the contrary. And then what it does, it talks about the court shall not order someone to give testimony or produce documents or other things. In addition to the provisions of this title, Vermont law also provides protections in its rules of civil procedure. And so, or criminal procedure. And so what I would suggest is that it say, notwithstanding any other provision in this title or rule to the contrary. Thereby you make it clear that you're not requiring any objections under this section to be solely within this chapter. But again, recognizing that we do have a body of law in Vermont that is currently used in civil and criminal actions and family actions for that matter that address these issues. To the extent that there are concerns about how the rules may work with this new statute, I would suggest that once the legislature, if it passes this bill and it's signed into law, the rules committees have an opportunity to reach out to notice an opportunity to be heard, essentially. They reach out to the bar, there's a period of comment, and the rules committees can then actually consider adopting rules that would further what is intended to be done with the statute to address more specifics. Perhaps they would put in provisions of affirmations or certifications under rules of for seeking an out-of-state subpoena. But that would be something that the rules committees would have an opportunity to do. And of course, the legislature does have the opportunity to review and approve any rules that are adopted by the rules committees and by the Supreme Court. So it's not as though you're just handing it over to the rules committees of the court to say whatever you come up with is okay. It is reviewed by the legislature.
Can I ask a question? I had a note on this, so I'm just going to ask in general if you feel like you can speak to it or if you know who we should ask to. But somebody brought up the question of, so somebody's asked to provide testimony or documents related to something. How will they know that it's abusive litigation? Like, how do they know that in advance?
The individual may or may not know. They could file something with the court to say that they would like something to be quashed, what we said a few moments ago about the rules and having that opportunity, they can try to file something there. But that's also a reason that a Rules Committee may determine that if a subpoena is being issued under Rule 45 from an out-of-state subpoena, if someone's seeking documents under that, the Rules Committee could potentially come up with a rule that says they have to have a certification that it's not abusive litigation as defined under Vermont law. So there are areas and ways that can be addressed.
Okay, and so you're saying that we don't necessarily need to put that, clearly state that in here, that would be under the rules? Or if we add that piece, notwithstanding in a provision in this title or a rule?
Right, you would provide the Rules Committees an opportunity to add some further clarity and address more specifics if it's deemed appropriate. And if the Rules Committees would not go in that direction and the legislature concluded that it's something that you feel should be there, you do have the authority to come back. In the bill, you could do it, but you have the ability to come back in the future and change the rules.
So a follow-up on that conversation. So changing or requiring certification, it seems to me that kind of gets at Sarah Teachout's issue of reversing the standard of proof. If we require this certification, that means they have shown or had said that this is not abusive litigation. So do I have that right?
That's correct. I believe that's what it would be, and that's a policy decision.
So the other question I have is recovery of costs for quashing a subpoena. Is that common? Does that happen already, or would we, if we want to do that, would we need to put that into the legislation?
Well, it is something that is provided for, I believe, generally under the law. You see that happen a lot. I can't sit here and tell you that statistically it happens frequently. If this committee believes that that is something you want to highlight, I would suggest putting it in the bill to clarify that this is something we want the judges to be aware that absolutely this is a right and this is a remedy. And also it puts the individuals who are parties to the actions on notice of that and removes any lack of clarity from whether or not someone can say, well, I didn't know I'd be liable for fees if I lost. You do know because it's in the statute.
And one last, Karen.
Go ahead.
So do we need to have something in here asking the rules committees of the court to proceed with this, or can that be offline and informal?
It could be either. You could put something in.
Something in session
laws. Yes.
All right, thanks.
And I guess that gets to my question. Like, I'm trying to understand the downside of saying that a rule should be established requiring certification of abusive litigation. Like, is it a turf thing? Like, this is like, Judiciary would rather us not, say what you need to do. I'm just putting it out there. I'm trying to understand. So anything you can help.
While the legislature has the ability to change the rules without going through the Rules Committee and the notice and comment period, it is generally a better rule if we have a notice and comment from the practitioners, the attorneys of the state, and others who are going to have to follow those rules. And so it would be my suggestion when we deal with rules changes, unless there is an emergency reason or something is wholly not addressed, that it go through the normal notice and comment period. And again, if there is a request, whether it's informal by the chair of House Judiciary or whether you wanted to put something in a statute, it would be addressed. It's something that would be addressed by the committee.
That's helpful to know. And I appreciate, when I see things like that, I just want to ask the question. So thank you.
And if one is very excited about judicial rules, there might be spots.
Oh, boy.
The joint rules, the joint committee, that we get to pour over all the details of all the.
Okay, I'm gonna, no more questions.
No, I'm not saying you, I'm just offering it to everybody, because I think we need a couple more people on that committee.
And the last topic I wanted to touch on was at the bottom of that page, section 7306, non-cooperation. It says no public agency or employee, appointee, officer, or official, or any other person, it talks about may provide information or expend or use any time. Now, please forgive me for getting this in the weeds on it, but theoretically, what that really says is even the judges can't spend time on this. In other words, if no public official can spend any time on dealing with these cases, I know it would lead to an absurd result. But my suggestion would be actually adding a separate standalone section at the end, perhaps a section C that says notwithstanding any provision in this section, this shall not prevent a court from addressing any issues arising under this chapter within the court, something like that. But when I saw that, I went, well, looks like we're not going to be busy on this.
Okay.
So those are the comments that I had as far as the structure. If there's any questions, I'd certainly be glad to answer them if I can.
We're not asking questions.
No, I don't want to, suppress you.
Kidding. Talk about squashing, right?
Thank you.
Thank you very much. Thank you.
Have a great day, everyone. Take care.
Let's take a 10-minute break. Warm in here and after lunch and